Good morning. Thank you for joining the Know Your Rights for Local Businesses. My name is Diana Perez. I'm a staff with the Chicago's Committee on Immigrants and Refugee Rights, chaired by Alderperson Andre Vasquez, and I'll be moderating this virtual event. This virtual event will be recorded, so we ask you if you don't feel comfortable writing any questions in the chat, or if you want to turn your camera, please feel free to do so. We know that it has been a few weeks where the new administration took office, and there has been a lot of executive actions taking place and a lot of changes. And we know that there's a lot of organizations doing Know Your Rights to ensure like community members are informed about their rights. So today we wanted to also ensure that local businesses know about their rights, especially if they have any interactions, right, with ICE in the community, and to ensure that their employees are also protected. This virtual event is in partnership with the Anderson Chamber of Commerce, with the Rights Chicago, the Illinois Hispanic Chamber of Commerce, and the Consulate of Mexico. So before we start, I just want to highlight that those who are joining us for this virtual event, please feel free to write any questions, and we will be answering any questions that you have at the end of the presentations. So, and I also want to ask, please mute your mics, as we want to ensure, it's just the presenters, who are speaking as we go into our agenda for today. So, as we start now, I want to introduce Jorge Mojica from Rights Chicago, that will lead us into the Know Your Rights presentation for local businesses. So now I'm going to pass it to Jorge, that will lead us into this presentation. Jorge.
Thank you very much, Diana, and thank you to Alderman Vasquez and the Immigration Committee of the City of Chicago. I'm going to start a slideshow right away, but by the way of introduction, we are a worker center. I'm an organizer of workers to ensure their labor rights in the workplace. But of course, when we face immigration and the immigration threats posed by the new administration, we understand that everybody has to act together. And so, despite the fact that we only work with workers most of the time, we have decided to collaborate and also extend our knowledge to business owners. So let me start sharing my screen and go back to the beginning. So we call this Protecting Businesses, Clients, and Workers, because everybody's part of this community. We were founded in 1991 by religious leaders. Rights Chicago is a nonprofit organization focusing on educating, organizing, and supporting workers to make sure labor laws are respected in the workplace. And today we are going to talk about 4 topics that are the crisscrossing of immigration and workplace. We're going to talk about rates in the workplace. We're going to talk about the I-9 audits. We're going to talk about the use of E-Verify in the workplace. And lastly, we're going to talk about the IRS no-match letters. Some of you may be familiar with some of this. Some of you may not. So we will go detail by detail in some of them. First of all, the I-9 audits. The I-9 form is the form every worker has to fill when hired. Is the form that has 3 lists of documents, basically to prove identity of residence and work permit, work authorization. These documents, every worker fills them out. The employer has to keep them, and on occasion, immigration can request copies of the I-9 forms. We have to be very detailed in this sense. The Immigration and Nationality Act authorizes ICE to ask only for the I-9s. It doesn't say the other documents the worker presented to you, whether it's a green card, a driver license, social security card, anything else, passports, nothing. ICE only requests the I-9 form. So our suggestion is to keep separate all the information just to keep the I-9s in one file, and do not file other documents alongside with the I-9 forms. If ICE comes to your workplace requesting the I-9s, deliver them only the I-9s. You have 72 hours to comply, 72 hours to deliver these I-9s to ICE. Consult with a lawyer, of course, if you receive a request from ICE. And remember something, all employers have what is called a safe harbor provision in the Immigration and Nationalization Act. You are not responsible for what documents the worker presents to you when the worker files the I-9. They may present a green card, they may present a driver license, they may present a work authorization, so-called EAD. They may present a letter from the Department of State. They may be on their DACA, they may be on their TPS, temporary protected status. There are so many immigration documents that the law recognizes that the employer is not knowledgeable, on immigration documents. So the I-9 form in page 3 and also repeated in page 4 clearly states that the employer only has to look at the documents a worker presents, and if they appear to be genuine, that's good enough. You don't have to be an expert. You don't have to certify that the document is valid, is not valid, etc. Is just to the best of your knowledge, the employee is authorized to work in the United States. That's the only responsibility of the employer. You don't have to go further than this. Usually, that's our experience. An I-9 audit, the immigration agent or the immigration office checks the documentation in the I-9 against the databases of the Social Security, databases of Immigration and Enforcement, UCIS, the United States Citizenship and Immigration Service, even the FBI databases, and they come back to you telling you that some of the workers have information that is not found in any federal database. And therefore, they assume these workers are undocumented and you would have to fire them. In our experience, immigration does not detain workers. It just gives you a timeline, 10 days, 15 days. You can actually negotiate with ICE depending on the size of your workforce, depending on how many workers they found to be undocumented and you have to fire. You will have to fire them at the end of the day, at the end of the time. But it may be 10 days, it may be 2 weeks, it may be even 2 or 3 months. Please don't fire the workers before you have to fire them. Don't panic and just start firing people before ICE comes back with the result of the I-9 audit. And in case you have to fire them, please collaborate with them. They have built your business. They have been there working every day. And if you can help them in some way, pay the wages until the last day they worked, pay, if they have separation policies, 401k pension funds, etc. That's money that belongs to workers, and the workers are entitled to get it. So consider even seniority pay, separation pay, even contribute to some legal fund if the workers have the need. In the end, they help you build your business, and you can help in so many ways if the workers have to be fired. Let me go to issue number 2, the IRS no-match letters. Usually, after the employer files taxes, he or she, the company, may start receiving IRS no-match letters, basically saying the information you are sending us does not coincide. There may be mistakes, there may be typos, there may be changes in immigration situation, there may be unreported changes after marriage, divorce, etc. So as far as we know, there are 18 million mistakes in the database. It's not unusual to find mistakes, names in different languages that were written wrong. Even we have some dyslexic people. We found, and this is a real case, we found a case of a worker whose date of birth was 1492 instead of 1942. So basically, the guy was here when Christopher Columbus arrived to this continent. So there are so many mistakes. The IRS is going to send you a letter asking you to correct the information. Or basically, I should say that the worker should correct the information. It's not up to the employer to correct the information. The only obligation of the employer is to communicate to the worker that there is a problem with their information and then notify the IRS by August 1st that they already communicated to the worker that there's some kind of mistake, some kind of problem with their information. You are not obligated to do anything else. You are not obligated to check the workers' documents. You are not obligated to demand workers to give you the documents. It's a matter between them and the IRS. According to the manual, the IRS manual, the worker has until December 31st of the year in which they receive the letter. They don't have 15 days, they don't have 3 weeks, they don't have 1 month. They have until December 31st of that year. If there are no corrections by December 31st, you may expect a second letter from the IRS the following year, 2026. In that case, again, your only obligation is to notify the worker that there is a mistake. And again, the timeline to correct the mistake is December 31st of that year. Only 2 years. So basically, until December 31st of 2026, you practically don't have to do anything. Just communicate to the worker that there is a mismatch, a misinformation in their documents, and then communicate to the IRS that you already told the worker. The fines for an employer, if you do not respond to the IRS by August 1st, is $50 in the first year and $260 in the second year. So please, if you do receive a no match letter from the IRS, do not ask workers to file new W-4s, I-9 forms. This is not required, is not going to solve the discrepancy. Do not use E-Verify with current workers. That may be illegal. Do not fire anyone. You might be liable under federal, state, and local laws. And according to the Ninth Circuit Court of Appeals, receiving a no-match letter is not a just cause to fire union members. So,
Oh,
sorry? Oh, that's it for the IRS. The E-Verify program in Illinois. You may know that E-Verify is a voluntary program. You are only mandated to use it in case you have a contract with the federal government. If you have federal funds coming to you, then you are mandated to use E-Verify. Otherwise, you are not obligated to use it. The use is voluntary. And in the state of Illinois, there are several requirements in order to use E-Verify correctly. You have to register with the Department of Labor, Illinois Department of Labor. You have to attest that you took, or the employees who are going to be using the database were duly trained, fully trained. You have to attest that you are not going to use the information for anything else except that for hiring a worker and checking their work authorization. Using the program voluntarily means you cannot verify workers who are already working for you when you register for the E-Verify in the state of Illinois. Basically, if you use E-Verify, you can only use it for new workers. Otherwise, you would be violating the manual itself of E-Verify program and, of course, the new Illinois Right to Privacy at Work Act. That went into effect January 1st, 2025. You have to sign affidavits that you were enrolled, receive the E-Verify training materials, and also to have conversation with the Department of Labor in order to learn the cost of using E-Verify and the so many mistakes. The 18 million mistakes I was talking about repeats here in the E-Verify program. Again, a typo. Again, a change in the immigration status of a worker. A change because a woman gets married and start using the last name of the husband. A woman who gets divorced and starts using again her maiden name. If that goes unreported, then it's going to cause a mismatch while using the E-Verify program. So the Illinois Department of Labor has a special program to monitor companies, and there are severe fines for employers who do use E-Verify in an illegal way. You have 72 hours, I'm sorry, the 72 hour rule is called 72 hours to verify the information of a worker after you hire them. We know that several companies are asking potential workers if their documents would pass E-Verify. That's absolutely illegal. If a worker you believe is qualified for the job, you hire that person, and on the first day, that person files the I-9, and that is the information you use to send to the E-Verify program. But you cannot do it. You cannot use E-Verify before hiring that person. That would be illegal. If in 72 hours you consider that that worker doesn't have any problem, then it is understood that the worker can continue working. If you get a notification from E-Verify that the documentation does not match, the worker may still continue working, but you would ask to make corrections, and the worker has the right to present different documents, clarifying if there was a typo, if there was a mistake, if there was whatever unreported changes in their information. Notify the workers, please. E-Verify, is not a private information. You have to tell the worker. You can tell the worker. You can give them the notification sent to you by the E-Verify program. It's not anything that you can or you should hide from the worker. E-Verify would state clearly what the discrepancy is, and you have to tell the worker exactly what the problem is so the worker can try and correct it. Very important, do not re-verify workers. Knowledge came to us that apparently immigration started sending letters to some companies saying, if we catch you with undocumented workers, we will fine you $10,000. Well, you don't have to re-verify. As a matter of fact, it is illegal to re-verify certain workers. You should not re-verify the employment authorization of a U.S. citizen and non-citizen nationals or lawful permanent residents who presented a permanent resident card, the famous green card, or other employment authorization documentation that is not subject to re-verification. Re-verification does not apply to List B documents. If you're familiar with the I-9 form, you will remember there's a List A, List B, and List C. List A proves both identity and work authorization. List B proves work authorization. List C proves identity. So there are certain documents in the List B that should not be re-verified only. Re-verification may not apply to certain non-citizens. So please check the manual, the E-Verify manual. This paragraph I'm pointing out here comes from the Department of Justice. The Department of Justice has a particular office called the Office of the Special Counsel to Prevent Discrimination Against Immigrant Workers. and re-verifying workers illegally may prompt an investigation by the Department of Justice. So also in the manual, in the E-Verify manual, you can see page 12, a particular note: U.S. citizens and non-citizen nationals never need re-verifications. Do not re-verify the following documents: an expired U.S. passport or passport card, an alien registration receipt card, a permanent resident card, this is the green card, or a List B document that has expired. So basically, uh, you cannot, under any circumstance, use E-Verify to re-verify workers, except in one particular case. If a worker presents to you a document that has an expiration date for the work authorization, DACA, for instance, the famous Dreamers. Dreamers have work authorization that expires in 4 years. So every 4 years, they have to renew their work authorization. But a permanent resident card, a green card, the card itself may expire, but that doesn't mean the immigration status of the person changed. These are permanent residents, permanent, forever, despite the fact that the card may expire. If the card expires, it's just like a driver license that expires, but it doesn't change the immigration situation of the person. If anyone presented you with a green card when you hire them, you do not have to re-verify that person. And now we go to the next one, ICE in the workplace. And we have been very busy educating people on their rights at home if immigration shows up. Basically, an employer has the same rights of anyone in their private property. If ICE agents do not show a warrant, they cannot enter your premises. What we call a raid is different from detaining just one person. There may be occasions when ICE shows up just trying to arrest one particular person, and that's different from a raid in the workplace. A raid in the workplace very basically is, let's catch anyone we can catch. And just going after one person, it is an individual arrest. You have the same rights anybody has. This is your private property. Nobody can enter your private property without permission or with a legal warrant. So prepare just in case. Have a written response plan. Know your rights, and not only you, but let your workers know their rights. If ICE enters a location, whether because they have a search warrant or whether because they force their entry, teach your workers to keep quiet, not to talk, not to interact with anybody. If they have them, show their red cards, which is the my right to remain silent card. Practice just like a fire drill. Be prepared and nominate someone. Have someone responsible for your location. Have someone, a supervisor, a manager, a shift manager, a plant manager, somebody responsible for entry or not entry to ICE. Do not allow anyone just to open the door. Do not allow anyone just to allow entry to immigration agents until after seeing if they have a search warrant. So be prepared. Uh, Check with your lawyer. If ICE shows up, immediately call your lawyer. Everybody should have this post at their workplaces. You know, this is private property. No one can enter without a legal warranty. If you do not have a legal warranty, we will not open the door, and employees are not authorized to consent access to this facility. There are some places the restaurant is the best example, maybe, that have public areas. Anyone can enter a restaurant, but nobody can enter where the cashier is located. Nobody can enter the kitchen. Nobody can enter the office in a restaurant. So public area, yes, that may be accessed by ICE agents, but no further than that. So not only the poster at your door, but the private area posters should be posted all over the place. Nobody has the right to enter the kitchen. Nobody has the right to enter the office. Nobody has the right to go behind the counter. Post. Restricted areas, authorized personnel only. Mark them, just like you would mark in any private property. You can mark your house. You can mark your garden. This is a restricted area. If ICE shows up with a search warrant that specifies that they have the order to search the kitchen, then they could actually access the kitchen. But just a search warrant with your address does not allow them to enter private areas. So please be aware. Please get your posters. We have posters, or you can buy them anywhere. It's pretty easy to get a hold of these posters, and you should have them all over your place. If ICE agents show up with an arrest warrant, that is only for one person. That doesn't give him the legal permit to enter the premises. If they are looking for an individual, they can wait for that individual in the sidewalk. They can wait for that individual in the parking lot. They can wait for that individual in the alley, wherever they want, but that doesn't give them legal access to your workplace. You do not have to collaborate. You don't have to tell them, yes, he showed up to work today, or he didn't want to. He didn't show up to work today. You don't have to tell them he works in this particular department. He works in this particular area in your workplace. It's not your obligation to collaborate with immigration if they are looking for one person. Uh, of course, you will have to remember that ICE does not have arrest warrants most of the time. There is a legal case here in the city of Chicago, the Castañón Nava case. Castañón Nava was a person who was detained, arrested without an arrest warrant, and the judge ruled in his favor. Basically, to arrest a person without an arrest warrant, uh, the arresting officer would have to prove that he knew or she knew that the person was an undocumented worker. And there's no way to know if anyone is undocumented just by looking at them, just by talking to them. They may not speak perfect English. They may not speak English at all and be US citizens. There's no way to just looking at a person know that that person is an undocumented immigrant. So if ICE shows up with an individual warrant to arrest somebody, do not allow them to speak to other workers. Tell the workers to keep silent, to keep quiet. They do not have to respond to ICE agents if they don't have particular particular arrest warrants for them. That'd be pretty much it on my side, and I would be available for questions and answers. Thank you very
Thank
much.
you. Thank you, Jorge, for your presentation. Obviously, as we learn about how you could protect your rights as a business owner and your employees, I think it's also important to know about some of the resources out there. Right now, I would like to introduce the Consulate of Mexico, the Deputy Consul General the Deputy Consul Gerardo Guerrero, that will share with us some of the resources and an initiative that they work with the Hispanic Chamber of Commerce.
Thank you very much. On behalf of the Consul General of Mexico in Chicago and also of our Consul General, I would like to thank the Committee on Immigration and Refugee Rights and also Alderman Vasquez for organizing this event and for having us with you to talk about these important issues. As you mentioned before, we have been facing not easy times for some members of our community. And among the different resources that we have for our community is we provide different kind of road shows for people, to for them to be well informed about what kind of actions they can take. And one of these road shows is something that we call in Spanish, más vale estar preparado. So in English, this could be something like, it's much better to be ready. Samantha, next slide, please. Among the different conversations that we had with the Hispanic Chamber of Commerce, is that we were working about these road shows with our community. One of our main concerns is that in some families, there are, for example, minors that they don't, they are not Mexican citizens yet. So our concern was, well, what's going to happen with these kids in case, or these minors, in case their father or their mother or their parents, both parents might be deported. So talking with the Hispanic Chamber of Commerce, we realized that we haven't done anything for our business community. So talking with them, we start working to put some material together in order to provide to the community with different tools in order they might be prepared in any case of deportation. Next slide, Samantha, please. So, on that regard, the Hispanic Chamber of Commerce launched a few weeks ago the tools to protect your business, be prepared in case of deportation. This is a very important program to provide a small business owners with the resources they need to make sure their business can continue operating in the midst of deportation. But it also provides tools not only to ensure that businesses can continue to operate, but this is also an important way to protect employees who, through years of effort, have managed to build their assets. Sometimes, there are topics or there are issues that we don't like to talk. And I think that this is one topic that we don't like to talk. But, this is the right moment. This is a moment where it's very important that we sit with our families, that we sit with our business partners, to talk about what might happen if I know that I am an undocumented person, or if I know that I might have a deportation order, or I know that I might be in any risk to be deported. Is the right moment that we need to sit with our family, with our business partners, to talk what we are going to do in case I'm deported. How my business, how my assets are going to be well protected. So, one very important way that to do this is, as we find the way to do it with minors through the guardianship agreement. This is a document that you give authorization to another person to take care of your children. Well, we also have some tool for entrepreneurs, for business. If I am a person that I have my own business, but even if I don't, I'm an employee and I may have a property, or I may have a checking account, a saving account, what is going to happen in case I'm going to be deported? So one very important tool is the power of attorney. According to the Illinois Power of Attorney Act, the purpose of this kind of instruments is to give the designated agent broad powers to handle the principal's financial affairs, which may include the power to pledge, sell, or dispose of any of the principal's real or personal property, even without his or her consent or in advance notice. That is why it is very important that when we pick someone to be our agent, this person might be someone that is of our totally trust. We need to trust in this person. But something that is very important is that when we pick someone to be our agent to execute this power of attorney, it needs to be someone that has a documented, a legal status in the United States. Because if we are going to pick someone that is like us, that is undocumented, that they don't have a regular status in the United States, it's going to be the same problem. Because in the future, this person might be also deported, and the situation is going to be the same. So we need to find someone that accepts to be our agent, that has a legal status in the United States, and this person, well, is going to act in our duty. This person needs to act in good faith, or because they are going to work for our benefit. They are going to take care of our property, of our assets. So it's very important that we choose someone that we totally trust in that person, but also that they have a legal status. Next slide, please, Esme. Uh, as I mentioned before, the Illinois Power of Attorney Act is regulated in the sections 3 and 4 of this act. So can you open the This is something that is very simple to do. If you enter in this page, you are going to find the template that is provided by the Illinois Power of Attorney. I always say that when we grant a power of attorney, it's like, when we are going to get a new suit and we go to the tailor, the suit needs to be tailored to our specific needs. There is no way that, any case is the same to other case. Any case is a particular case. Any people has a specific needs. So it's like when you get a suit. This suit needs to get, needs to be done to your specific needs. ¿No abres, me?
No se ve.
Well, basically, we can continue. Basically, the form prescribed in the section 3 of the Illinois Power of Attorney consists of three documents. First of all, is a notice to the individual signing the Illinois statutory short form power of attorney, which is like, is like the application form. So it's going to give you the whole information about the power of attorney. And as I mentioned before, this is something that is going to be made specifically for your needs. So you need to fill out this application form, and you are going to state different information. For example, your address, the address of the person that you are going to give this power of attorney, what kind of powers or what kind of faculties you are going to give to this person. And also it has properly what is called the power of attorney. These are, the principal these are the principal powers that you are going to have in the template given by the Illinois Power of Attorney Act. But you don't have to grant all these. You don't have to grant all these faculties. You can strike if you don't want to give your agent one of these powers. You can strike that power of the model of the template. So in this case, for example, if I don't want that my agent handle or administrate my real estate transactions, well, I want to strike that. Next one, Esmer, please. Here is a brief description of the different faculties that we are going to have in the power of attorney. For example, if we are going to have real estate transactions, the agent is going to be able to buy, sell, exchange, rent, and lease real estate. For example, if we are going to give him a power for financial institution transactions, he's going to be able to open, close, continue and control all accounts and deposits in any type of financial institutions. For example, if we are going to give any kind of power for tangible personal property transactions, this person is going to be able to buy and sell, lease, exchange, collect, possess, and and take little title of all tangible personal property. So these are
Good
all.
morning. My name is Camarina. I'm calling from Blackview.
Sorry.
No, continue.
Sorry. So these are all the powers that is going to have the template, but you don't have to grant all the powers that are considered in the template. You can strike those that you don't want your executor, your agent exercise. So as I mentioned before, it's something that it needs to be done to your specific needs. The legal advice that we give is that you use this template that is contemplated in the Illinois Power of Attorney Act. But also you are free to give a power of attorney that is a non-statutory property power, and this can be granted filling out these essential requirements. If you are not following the template that is given to you in the Illinois Power of Attorney Act, you can use another template or you can use another model, but you need to be very careful to fill out with these requirements. First of all, must be executed by the principal. Second, you must designate the agent and the agent's power. And third, must be signed at least one witness to the principal's signature. So you need to have a signature when you sign this power of attorney. You need to sign. You need you need to have a witness that he witnessed that you signed this power of attorney. And very important, must indicate that the principal has acknowledged his or her signature before a notary public. You need to sign this in the presence of a public notary, and you need to show your ID in order to grant this power of attorney. Unless the principal specifically limit the period of the time that the power of attorney will be in effect, the agent may exercise the powers given to him or her to the principal's lifetime, both before and after the principal become incapacitated. A court, however, can take away the powers of an agent if it finds that the agent is not acting properly, or the principal may also revoke the power of attorney if he or she wishes. It's very important that you know that you can, give this power of attorney as broad as you want. You can, for example, establish a limit period of time to exercise the power of attorney, or you can leave it as broad as you want. So it's something that you need to do according to your needs. And while this is a very important tool that you can have in order to, protect your assets. And if you feel that you are in risk to be deported, or that you know that you might have a deportation order, well, it's very important that you think about this important tool in order to protect your assets, your assets, your patrimony, and your family. Thank you very much.
Thank you so much, Consul Guerrero. And now we invited a local business that is going to share his testimony on how he has implemented and is preparing in case of any ICE activity at his local business. And I would like to now invite Miguel Angel from Manhattan's Restaurant to share a little bit of how he is preparing. Miguel Angel?
Hello, everyone. Can you hear me properly?
Yes.
Yes. Well, thank you for having me. It's a great honor to be here with you and to be learning about this situation and the social crisis that our community is going through. And the people that are, everyone, I would say, has a loved one that is at least more concerned about this particular situation than many others. But hopefully we can get through it. As Jorge Mujica mentioned, he gave an example about a restaurant, about how the ICE agents could come in there and they basically would just be able to ask questions, come into the general area because it's a public area, it's a restaurant. And that's my particular situation. So the way I planned speaking to my staff was to notify them, to let them know that it could happen, that we are vulnerable. The immigration czar, as he is being called, or the immigration head of the department, back in November or December or so, he threatened very harshly Chicago as being a sanctuary city, that he was going to be very hard on our city, on the Windy City, because the city has been a sanctuary city for many, many years now. And therefore, he was going to pound it hardest to show the show of force, basically, that this administration has been enforcing on us, if you will. So the way we are preparing to it is obviously, as the many workshops that I've attended with Arise. Jorge Mujica has been doing a great work, and other community leaders. Thank you so much. We started by posting the notices that it's a private place, even though it's a general area where the clients can come in, but the private areas are where they cannot come in unless they show proper documentation. And that's how we've been preparing with it. I've informed them, not in formal meetings, but I would say it's more of a personal thing. I've also talked to them individually and as a group, because I feel like if it's more of a formal meeting, you kind of panic more. They feel as if they are scared more, as the mass media. Unfortunately, many channels out there of communication and social media, they are profiting from this, because keeping our community in panic gives them more power, so that they are more attached either to the TV or to the social media. So I recommended to them that they attend these particular workshops, so that they are more informed in the proper way, which are, it's true. These particular workshops are very, very informative. And again, I thank you very much for having these, because unfortunately the media is not doing a great job about this. They're only keeping our community in panic, and they're not informing them properly. So obviously, as Jorge and the Arise community, the workshops have done, Know Your Rights. One is, ask them for proper documentation. Ask them for do not incriminate themselves, do not talk, invoke the Fifth Amendment. I have the right to remain silent. Record if at all possible. Do not sign anything. Do not incriminate anybody else, as this famous case that Jorge has mentioned, that they don't know anybody, is undocumented. ICE has obviously arrested, as the media has communicated, arrested Hispanic-looking or brown-looking people that are citizens, and they have wrongfully arrested these people. So 100% they're not sure. So that's what I communicated to them. Do not give them a reason, even if they disrespect you, or even if they try to intimidate you, basically, or by disrespecting, I say intimidating. If they try to intimidate anybody into telling them, well, if you don't talk, if you don't sign, stay calm and be as polite as possible. Do not bring out your consulado matricula, because as Jorge has mentioned in these workshops I've mentioned, that would be incriminating yourself. So that's what I've communicated to them. Right now, we're not hearing as much as these cases anymore, or these raids or these arrests in the last couple of weeks. The federal administration has been focusing on other issues, and thankfully, this has taken a little bit of a backseat. I'm not saying it's gone away. It has taken a little bit of a backseat to the media and to being in the front end of our minds. So I feel that at least in the last 10 days or so, or the beginning of this month, our community has been able to focus on their particular lives and going through their lives as normal as possible. So that's what I communicated to them. And hopefully that has given them more confidence on and going through their normal life and not being scared about being arrested or having a raid in their workplace.
Thank you, Miguel Angel. And now we're going to take some questions. I'm just going to stop the recording, but we appreciate you sharing your testimony as a business owner, the importance of ensuring that, you know, you inform your workers about their rights. Thank you for that. And now,